Hello, this is Pattyjo, and we are continuing with the meltdown at the end of this, trying to get to the process of saying that, you didn't have anything to present, Daryl. you did. Woo! All right.
You asked me a question, now I can't answer.
Yeah, no, go ahead, answer.
You're trying to coerce me into violating my right to remain silent.
No.
How can you coerce me into my right to remain silent? So you're not going to protect my constitutional rights? Because I didn't answer nothing that you
Oh, there we go. Now it'll go back.
You're trying to you asked me a question, now I can't answer.
Yeah, no, go ahead, answer.
You're trying to coerce me into violating my right to remain silent. How can you coerce me into my right to remain silent? So you're not going to protect my constitutional rights? Because I didn't answer nothing that you was trying to ask me before when I had the headphones on.
When I had the headphones on.
You can't do that.
You can't do that.
You're violating my constitutional rights.
You're violating my constitutional rights.
If you'd like to testify, then you need to simply go through the colloquy with this court, which I've given you 3 opportunities to do, and you have decided not to.
No, you can't tell me what I decided to do.
You can't tell me
to do or not do anything.
Are you willing to?
Your Honor,
mocking
by
him.
law, you cannot coerce me.
I'm not coercing you, sir.
Well, you're making a decision for me based on something that I did not say myself.
Last Friday, I specifically directed your attention to State versus Anthony. I discussed very briefly at the end of the day on Friday the case law that is relevant on this topic, including State versus Anthony, Rock versus Arkansas, and Chambers versus Mississippi, to specifically put you on notice.
Did you recall what was going on Friday?
Mr. Brooks, I'm going to mute him. Again, I'm not going to have a debate. I've made a finding. I've given him yet another opportunity. If he's willing to go through the colloquy with the court, he wants to challenge me instead and saying he doesn't consent. His lack of consent to this entire procedure is noted for the record. Based on his inability to pledge to this court that he will honor that ruling and be respectful of the jury, I'm going to leave him in the other courtroom. The jury's going to be brought out, and he will remain muted, and I will simply advise them, as I have throughout this case, that he's appearing from another courtroom and that his appearance from the other courtroom should not in any way be held against him or influence their verdict in any way. I will tell them that there are no further witnesses for the defense, and then I'll ask the state if there is any rebuttal, and then the jury will be excused for the day, because we will have I anticipate will be a very lengthy discussion on jury instructions. Again, I will advise Mr. Brooks that if at any point in time he wants to come back over, he needs to advise the bailiffs, but it does need to be accompanied by a pledge that he will follow the rules of civility and decorum, and he will not specifically challenge the court's rulings regarding closing off of his ability to call witnesses or testify on his behalf. All right, let's have the jury brought out.
Oh, God. He just hates not being the center of attention and complete control. He's amazing. Ugh. Look at him. What an idiot. Ugh.
All right.
is he waving his arms around for?
Thank you, everyone. Please be seated. Ladies and gentlemen of the jury, at the moment, Mr. Brooks is appearing from another courtroom. This must not be held against him in any way and must not influence your verdict in any manner. At this time, I will advise the jury that the defense case is rested, and I'll ask the state whether there's any rebuttal evidence to present.
No rebuttal, Your Honor.
All right, then with that, I will declare the evidentiary phase of this trial concluded. I'm going to excuse the jury for the remainder of the day so that the parties and I go through all of the jury instructions, and I anticipate bringing you in tomorrow morning. Instructions may very well take most of the day. My hope is to then have the closing arguments and then have the case be turned over to the jurors. If not by tomorrow evening, sometime Wednesday morning or early afternoon. With that, I'll rise for the jury then. Please turn your notebooks into the civilian bailiffs. I'll get them back to you during deliberations. Thank you. Be seated. Before we begin, I will have Teresa print off what at least we do have for both parties. I'd like to take a short comfort break. I'll invite Mr. Brooks to come back over, and then we'll start with that jury instruction conference. We'll take about 10 minutes. Thank you, everyone. We are in recess.
Okay, so I am. Okay. All right, let's see. Go right there and see if we're close enough. Okay.
Sir, could you please raise your right hand? Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Oh, this is going to be about one of
Please
his
have a seat.
stupid little complaints.
Please state your first and last names for the record.
First name is Nicholas, last name is Kibler. First name Nicholas, last name Kibler.
Thank you. And you are a Waukesha County Sheriff's Deputy?
I am.
And have you been assigned to work this case?
I have.
And were you present in courtroom 20 this morning with Mr. Brooks when he was removed from this courtroom to that courtroom?
I was.
And did you make any personal observations regarding the audio and visual setup that we have over there?
Both the audio and visual were working properly. The audio was a lot louder than it has been in the past while we were in that room.
Did you have any difficulty hearing the court?
I did not.
And then, of course, you could see through the cameras from this courtroom into the neighboring courtroom.
I could.
All right, that's the only record I wanted to make. State, have any questions?
Just briefly, Deputy Kibler, the defendant asked many times if he was muted or unmuted. Do you remember that?
Yes.
Can you confirm that even on the occasions when his microphone was muted, the audio in the courtroom continued to work?
It was.
and at any time while Mr. Brooks was muted, or even if you didn't know, at any time did Mr. Brooks ask to be brought back over to this courtroom, sir?
He did not. He is telling us he prefers right now to be in that courtroom. He did not want to come back in here.
All right, thank you. Those are all my questions, Your Honor.
Good
Mr.
point.
Brooks, you are unmuted. Do you have any questions for this deputy?
No.
All right, thank you. You may step down. All right, then I'm going to have Zach Tremaine also take the witness stand. Do you have, I have it up on my screen. Can you do a, project it, please?
Can I just share it? Like if I share the clerk screen?
Yes. All right, there is, first of all, sir, stand and raise your right hand. Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? All right, thank you. Be seated. State your first and last name for the record, please.
Zachary Tremaine, Z-A-C-H-A-R-Y. Tremaine is T-R-E-M-A-I-N-E.
All right, and what is your position with the clerk of court's office here in Waukesha?
I'm the IT coordinator for the Waukesha County Circuit Courts.
Were you in courtroom 20 this morning following Mr. Brooks being taken to that courtroom?
Only temporarily. I was there when the call started, and then we came back to do a measurement of the DV meter later.
There's a document or a photograph that's displayed on the monitors throughout this courtroom. Can you tell me what we're looking at?
So my phone is in the photo, overlaid on top of what we call the X panel. It is our AV control panel. So you push buttons on it and actions happen in the courtroom, AV related. At that time of the photo, my phone is registering 67.3 decibels in that courtroom, and that was when the judge or the court was talking, and then the sound was coming over the speakers
Wow.
in the other courtroom.
Okay.
And what, if anything, based on your training and experience, can you tell me 67 decibels means?
It's plenty loud. For comparison, I did a quick reading in the media pooling room, which is CG6 in our courthouse. The meter there was reading between 55 and 65. So it's louder than the audio feed going to the media right now.
All right, thank you. Any question from the state?
Sir, I'm looking at the photo, and Your Honor, for the record, this photo will be made a court exhibit?
Yes.
Okay. I'm looking at your phone screen, and it looks like in the upper right-hand corner, it appears the time is either 9:26 or 9:36 a.m.
On my phone, yes, I believe our AV processor, which is the other time of 9:23, I believe that just needs to be updated, but
Okay,
it is approximately 9:26 when the photo was taken.
okay. Those are my questions.
All right, thank you,
Wait,
Mr.
I'm sorry.
Oh, go ahead.
Do you happen to know what the decibels are in this room?
I don't. I'd have to pull the same thing up on my phone while people are talking.
Okay, thank you.
Mr. Brooks, any questions for this witness?
Yeah, for the record, I don't consent to being called that name. Do you know anything about the hearing when someone has the hearing loss in any of their ears?
I do
Any
not.
of them?
So it'd be fair to say you don't know if I can hear everything good from this courtroom.
I can tell you what the readout of the room is. Beyond that, I don't know.
Well, I can't see what photo that everybody else is in there seeing that was supposed to be made an exhibit. I have not viewed that, so I don't know what's being referred to when you refer to the picture.
I'll have to show you that in a different way. I don't have the Zoom up and running, which would have been the mechanism to allow for an exhibit to be displayed. I can start that and have that up momentarily. Fair enough. So give me a moment. For the moment, we'll print it in black and white so you have it until I can get the Zoom up. Sure.
You are in the meeting now.
I need to get the other courtroom in, so just one moment.
You have to hang up after the call.
Yeah, I do that when it's too loud. Mm-hmm. Mm-hmm.
Will I have to stop the Polycom, Zach?
Yep, you have to hang up and then join into the Zoom meeting.
Okay, hold on, please. Can you do that?
What am I doing?
Stop the call Polycom to Polycom, and then I'm going to call it in through the Zoom so I can share the screen with the exhibit, which will actually help when we do jury instructions.
Copy that. I'm hanging up. So are you calling again?
Yep.
Okay, good.
Except now both the room systems are out, so hold on. One more.
You are in the meeting now.
All right, so the record should reflect that I've now changed the audio visual from the Polycom unit to the use of Zoom. I've called in both courtrooms, and they can hear from over there, and then I'll do, I just need to get back on so I can get the email. Give me a second, I have to go from double screen to single screen. The way I sign in, but that'll take me just a second, and then I'll share screen so the color exhibit can be viewed by the defendant. All right, now the court is sharing screen and the image is being displayed.
Yeah, I see it.
You see it? Okay, thank you. Any questions regarding that then, sir?
My question was, pretty much already answered. You don't know if me myself can hear everything good in the courtroom, correct?
I do not, correct.
No further questions.
Okay, thank you, sir. I'll stop sharing. Okay, thank you, Zach. You can step down. All right, I just wanted to put that on the record since
He complained about it.
that was an issue raised by Mr. Brooks previously. Now, I need to get a copy of the
You're coming.
jury instructions. They were quite lengthy. The record should reflect that Mr. Brooks was provided with a written copy. It's 107 pages, and the state was provided with a written copy as well. Again, it's all the same, 107 pages, and then my written copy is on its way.
I accept the value, return the value each document. That's if I'm not muted.
You're not muted.
I also would like to, again, ask for subject matter jurisdiction to be proven on the record.
Your request is
It
denied.
has yet to be verified. It has yet to be verified.
Your request is noted.
Your Honor,
It's denied without further hearing or consideration.
I was just told that, the evidentiary phase is supposed to be closed, how come I haven't been able to present my evidence into the record as I've asked numerous times on the record to be able to do? I've said I have numerous documents that needed to go into the record. Why have they not been permitted to be made evidence?
Evidence.
I
Because they're
didn't
not relevant.
rest my case, so I don't know why that's being told. And I have yet to be able to offer my exhibits into the record for evidence. How is that so, Your Honor?
So the court did declare the evidentiary phase of this trial closed. I specifically found that you forfeited your right to present any further evidence or testimony when you failed to answer my questions regarding the calling of witnesses. And then I also declared that you forfeited your right to testify. Specifically as it relates to your trial filing, sir, I would note that all evidence in a trial must be proper, it must be probative, it must be relevant, and it must follow all rules of procedure and all rules of evidence. To the extent that you wrote all of those documents, sir, that would be hearsay. And for that reason, I'm denying your request to make them part of the record.
They were not hearsay, Your Honor. I did what you told me to do. You told me, since I was representing myself pro per, that I had to write everything down and present them to the court.
So that's not what I said. You're misquoting me, but in any event, I'm
No, that's
denying
what
your
you said.
request. I
So
said,
you're saying that I have no right to present evidence and to have exhibits
not
as the
evidence.
state's been able to do.
Mr. Brooks,
Are
I'm
you
not
denying
going to
me
have
my-
a debate about this
Are you
now.
denying
I
me-
have,
are you-
I gotta
are you
mute
denying
him
me
once
your
again.
right?
So, Mr. Brooks, I have muted you because I declared the evidentiary phase of this trial closed. You forfeited your right to present further evidence and testimony
Look at him.
previously by refusing to answer the court's questions. I will specifically address the filings. Number one, it is not true that I advised him that any filing would become evidence. That is simply false. Number
Because
two,
it's dumb.
filings, I told him if he wanted to present motions, should be written down and should be based in law and fact and request specific relief. I'm well aware that previously he has referenced he would like his filings made exhibits. I've reviewed those filings. There's nothing relevant, nothing probative, or the information contained therein is hearsay. Mr. Brooks would have needed to testify regarding any statements that he, from himself, testimony. He cannot simply put in an affidavit. That's not proper. That's hearsay. And he hasn't asked in any of those filings that he hasn't put forth any exception to the hearsay rule that would allow this court to admit his written filings. I believe, without fail, they are all irrelevant, not probative, and hearsay, and therefore not admissible.
Wow.
So we're moving on to the discussion of jury instructions. When Mr. Brooks wants to abide by the rules of decorum and civility, I will unmute him. He clearly just took the entire packet of jury instructions and put them, I don't know what's under the table, if it's a garbage can or if he just simply put them under the table, but they are no longer in front of him. I will, however, unmute him so that we can get his feedback regarding jury instructions. It's typically a back and forth. We'll go through them.
Typically.
And I'll ask the parties whether there are any instructions they believe should be included, and we'll have a discussion on that, and then we'll talk about whether any of the instructions that are in here need to be modified in any way, taken out, edited, etc.
Beauty.
Right, you're unmuted now, but but you have to not interrupt.
You can't, I'm not trying to interrupt, but how can you deny me the chance to put on the adequate defense by saying nothing that you told me to do can be presented into evidence? So you filed them, you filed everything that I gave to you, you
Right,
filed.
Mr. Brooks, I'm
And
going
that's
to
all I'm
mute you
saying.
because this is not relevant at this time.
It is.
He's raised tone of voice. He's very animated. He threw the jury instructions on the floor. I understand you're upset, sir. I understand you believe I'm violating your right to present a defense. I've made my rulings. I determine you forfeited your right to testify, which includes the right to present evidence as you would have testified. I closed closed off your ability to call any other witnesses by finding that you forfeited your right to do so based upon your conduct. I understand you're frustrated. I understand you believe that I'm not without authority to do that. I made specific factual findings. I've referenced the law, and you being upset with the decision is not going to change my mind. He's also taken the headphones off. It's his choice right now whether he participates in this jury instruction conference. It is his choice. But if he is going to spout off about things that I've already determined, I will continue to exercise the mute function on the audio equipment. I'll unmute him again, but you are advised, sir, you need to be proper, you need to not interrupt, and you need to stay on task, which is we're discussing jury instructions, not other evidence, not subject matter jurisdiction, not your belief that I told you to file things a certain way. We are now discussing jury instructions. So once again, I'll unmute him to see if he can follow these simple rules.
You need to tell me why I can't present evidence. How can you deny me how can you deny me my right to present evidence?
All right, I'll mute him once again because he wants to continue. And again, I understand he's upset. I understand that. But he has himself to blame for his conduct this morning and the rulings that I've made. All right, so let's go through these jury instructions. First of all, has the state received a copy of the draft?
Yes, Your Honor.
Thank you. Mr. Brooks, do you acknowledge receipt? I believe you did by acknowledging it previously, but do you acknowledge receipt of the draft of the final jury instructions?
I didn't acknowledge nothing, and I don't
Yes, you
acknowledge
did.
anything now. I have not received anything.
I would ask the bailiff to
I
pick
don't
up the
receive.
documents from the floor and put them in front of him.
And
once again.
I'm not presenting it to nothing I don't give my consent to. You can't deny me the right to
You
put on the
accepted
How
for
can you tell
value
me
and
when
return.
I done stated
I'm going to
3
read
or
it
4
once
times.
again because, again, I understand he's upset. If the bailiff could
He accepted for value and returned for value. Not that that makes any difference because it's meaningless dribble, but he did. He did. You did.
confirm, well, he put him on top, he put him on the floor. That's his right. They're not in front of him, but it's by his own conduct that he's done that. The record should reflect Mr. Brooks is muted because he wants to continue to debate with this court about my prior rulings regarding his
This is exhausting.
forfeiture by conduct of his right to present further evidence on his behalf. I know one of the things I probably need to look at, I'm not sure if Madam Clerk did this or not, would be the language from the amendment from the amended information on count 70.
Oh, is this it? Is this it? This is it. I'm so excited.
76. The 76 count. Just wanna make- It says near
Here we
framework.
go.
so
We're
it
going to
is
make
in.
a 4.
That's just
Oh,
one
he
question.
fell down.
So state do you have any requests as it relates to the jury instructions?
Yes, Your Honor.
Thank you.
See if I backed it up enough.
Mr. Brooks, do you acknowledge receipt? I believe you did by acknowledging it previously, but do you acknowledge receipt of the draft of the final jury instructions?
I didn't acknowledge nothing, and I don't acknowledge anything now. I have not received anything.
I would ask the bailiff to
I
pick
don't
up the
receive.
documents from the floor and put them in front of him.
And
once
I'm
again.
not presenting it to nothing I don't give my consent to. You
I have
can't
to give my
deny me the
consent
right
to.
to put on the defense. How can you tell me when I done stated
I'm going to
3 or
read it
4
once
times?
again because, again, I understand he's upset. If the bailiff could confirm, well, he put him on top, he put him on the floor. That's his right. They're not in front of him, but it's by his own conduct that he's done that. The record should reflect Mr. Brooks is muted because he wants to continue to debate with this court about my prior rulings regarding his forfeiture by conduct of his right to present further evidence on his behalf. I know one of the things I probably need to look at, I'm not sure if Madam Clerk did this or not, would be the language from the amendment from the amended information on count 70.
The word. There he goes. There he goes. Yeah. Okay, he's gonna fall down. It's so funny.
76. The 76 count. Just want to make. It says near Frame Park, so it is in there. But that was just one question I had. All right. So, state have any requests as it relates to the jury instructions?
I'm just going through each one. I'm on page 50 of 107. Everything's looking great so far, though.
Okay. Fair enough. There's 107 pages. I certainly can give the parties some time to continue to read through them.
Yeah. Can't. I can't. Look at him. Oh my god.
Mr. Brooks is requesting to go back to his cell. At this point, I'm going to deny that request. He can remain in the other courtroom.
Oh my goodness. Big baby. He's yelling too. I wish I could hear it. He's yelling.
I know he's muted, but I can certainly hear him from this side. He appears to be yelling at the top of his lungs. I can't decipher what he's yelling.
Turn it on. Turn it on. Jury's not there to see these shenanigans. Shenanigaster. Look at him.
I'll advise Mr. Brooks, without a specific waiver of his right to be present, even if it's from the remote courtroom, he's going to remain in that courtroom. And that would require him to have a colloquy with me.
Wow. He's really mad. But look at how dangerous he could possibly be at this point. Look at how out of control his behavior is. Oh my goodness. That's a really good color for Sue Opper. She looks nice in that color.
Mr. Brooks, I know you are still muted by me, but I know the audio is working, but I would ask you to specifically advise if there are any specific jury instructions that you are asking be read to the jury.
Oh. Gosh, she's still at it. Don't you get tired?
Mr. Brooks, if you have specific instructions or categories of instructions that you believe this court should consider, I need you to write them down on a piece of paper. If you don't have, I believe I see a writing utensil. I'm not sure if I see a pad of paper. We'll make sure you have that. But given your current demeanor, which is still seems quite animated, and a loud raised voice, I'd ask that you write it down.
She knows it's a futile effort. is still hot.
How's the state doing on its review?
107.
Okay.
This is exciting. I'm gonna let it go through a couple more of watching him act like a big baby. Ugh. I might need to get a snack. 45 more minutes of this. Ugh. Ooh, it's not saying anything. Just sitting in this chair, trying to self-soothe. There he goes. There he goes. Ew.
I just want to make a continuing record that Mr. Brooks is still, I can still hear him even though he's muted due to his level, his tone of voice and volume level that he is using from the neighboring courtroom.
Unbelievable.
So all of these should be included, but they just put them in the numerical order. So you definitely haven't taken out any numbers. Yeah, there should be numbers. I can figure it out. There are numbers.
Okay.
Well,
I was gonna say, there's some, like the ones that are in all of ours, I think, are numbered.
yeah. So that's just the easiest because this goes after credibility. And then 325. Which, it's before defendant elects not to testify, and we have to talk about that one. Yeah. Mr. Brooks, I'll advise you once again if there are any specific requests for either instructions or categories instructions that you want this court to consider, please write a note to pass to the bailiffs who can let me know.
Look it up. Sorry, I just can't.
Specifically on page 63 of 107, when we talk about count 74 and 75, I think it might be helpful to put the Milwaukee case number, because they are different case numbers, so that they know exactly what they're finding, that he was out on bail and that as conditions of his release. And those bail bonds were entered into evidence.
Let me look at the information.
And then just, because I think this was just well, I guess I'll have you, when we look at the verdict forms on page 102 to 107 for the bail jumpings, there's verdicts for the bail jumpings for 3 separate counts, 74, 75, 76. I don't think there should not be one for 76. I believe that should be the battery.
That would be true.
That's a lot of proofreading. I can't even proofread an email.
My computer's just acting up a bit, so I'm gonna search, I wanna see what the information says. And then I'll ask Mr. Brooks if he has a position.
Oh my goodness.
Sometimes it's easier if we just list out, I guess, what the changes are requested. I'm
Sure.
gonna make some notes and then we'll go through
Sure.
them one by one, but so.
And I
first
don't
is
believe it
page-
was spelled out in the amended information.
Say that again?
I don't believe it was spelled out in the amended information.
Right,
So that would be page 63 of 107, whether or not we want to put the specific case numbers.
I can tell you right now, I typically like to follow the information, so I'm
Sure.
probably not inclined to do that, and we can argue that though to the jury, but
Okay.
let's go through the list and then we'll get
Okay.
the defendant's responses if he would like to give us those, but we'll go through the whole list. So that's the
then-
bail jumping.
Yep, and then with the verdict forms with regard to the bail jumping, just to put on the record, page 102 of 107, I believe there's a count 76, which details it as a bail jumping. I believe that should be the battery.
All right.
I did notice on the motive instruction was incorporated on page 5 of 107. And I know that intent is an element of the battery. I don't believe that was incorporated. I mean, usually it's a standalone instruction. I think the court incorporated it with the first degree intentional homicide because certainly that was,
I think that's part of the pattern instruction.
oh, it is. Okay, then we would ask for motive. I think that there's a 175 instruction that could be given as a standalone.
I'll look at that. Okay, we'll add that.
This is fascinating.
And
how
then
much work
on
goes
page
into this.
65 of 107, which is the 70, the preliminary instruction, defendant proceeding pro se. There's the standard paragraph, which is the first paragraph listed under this instruction, and then there's an additional paragraph. We are going to object to that additional paragraph. I think it highlights the defendant's bad behavior. So I'd ask that that be taken out.
All right, I made a note of that. Keep going.
Okay, with regard to page 106 of 107. I believe that those were add-ons at the end that the court wanted to question the parties about.
Yes.
I believe that there was 325 should be given. One of the witnesses for the state did testify. He did have one prior conviction. I believe a witness for the defendant testified that he had a number of convictions. With regard to that same page 106 of 107, instruction 141, where identification of defendant is an issue. I don't know if it is an issue. That wasn't raised during the defendant's closing arguments. His opening arguments. I would know that, or note that the defendant would sometimes cross-examine people on if they were able to see the person driving or the description of the person driving, and he would cross-examine them as to their ability to perceive that. So I guess that would really be up to the defendant if he wishes that to be given. On page 107 of 107, instruction 172, circumstantial evidence, flight, escape, concealment, the state that was included in the initial instruction that we requested, and I would continue to request that instruction be included.
And it's really just flight, though.
Correct.
What's that number again?
172.
Yeah, I know, it's just not there. I saw it, it's fine. But only as to flight. I made a correction on it, just gotta find it. All right.
And I would say concealment to some extent, because he took off some clothes that would have identified him. But again, his running away, his trying to conceal his identity by removing some clothing that was identified by numerous witnesses as him wearing a hoodie or a light colored top.
Those are all, and do you have any requests as it relates to instructions that are not in the packet that should be?
No, Your Honor.
Right, let me turn to Mr. Brooks just to get whether he has his list. I'm not asking for a response yet, Mr. Brooks. What I'm asking you for is whether you have any requests for jury instructions, or if in your review you think anything needs to be changed, deleted, added, etc. I know I'd ask that it be put in writing, but I'll also give you this opportunity to verbally advise the court and make your requests. Do you have any requests as it relates to the jury instructions, sir? I would note he put 2 boxes right in front of where he's seated, so I can't presently see his face. I see his jacket is off because I can see the outline of his arms, and I can see the jacket on the back of his chair. He is unmuted. I've confirmed previously regarding the audio working, and I will just ask him a second time, sir, do you have any requests as it relates to the draft packet of jury instructions, whether that be any additions, corrections, edits, or deletions?
And Your Honor, would it be possible for the bailiffs to just move the boxes off the table?
gonna be
Yes, I
funny.
think that's fair. I'm
That's
going
gonna
to
be funny.
advise the bailiff to remove the box so I can see Mr. Brooks. I don't know what he's doing behind there. He has quieted down. I haven't heard him in a while.
You gotta make sure he's okay.
If you could move the second one because it can interfere with the microphone as well.
You're
And
gonna
the
move them
third.
all.
Mr. Brooks, I'm going to ask you for a third time. Do you have any requests as it relates to the jury instructions? Any requests for instructions that aren't included that you believe should be included? Any edits or deletions from the packet that has been provided to you?
Hey, why do you tell them to move my box?
Because I couldn't see you, sir.
Or what?
I've asked you twice now, and I'll ask you a third time. Do you have any requests as it relates to the jury instructions? Any additions, deletions, edits, or
Hey
otherwise?
man, you
Hey,
don't gotta
man.
talk to me like that.
Do you have any requests
First of all,
related
what?
to the jury instructions, sir?
Man, yeah, I got requests. It ain't like they gonna be honored though, cause
As it
nothing
relates
I've
to
been
the
trying to
jury
get done.
instructions, sir, what are your...
I heard what the hell you said, man.
Well, Mr. Brooks, that was very disrespectful.
Yeah, and I've been getting disrespected since the beginning of this whole process. So welcome to the club.
Mr. Brooks, do you have any
I'm
requests?
tired of my rights being trampled on here too. I'm tired of it too.
Do you have any requests as it relates to the jury instructions?
Ain't nobody understand why I'm frustrated. How you gonna sit up there and make decisions based on what you think I said when I didn't give consent for you to do any such thing?
Sir, I understand you may be upset, and I really do,
No, you
but
don't
I've made my
understand nothing.
determinations.
You don't understand nothing. You don't understand anything, Your Honor. You don't. Because
I'm going to mute him again because he's not answering the questions that I'm very clearly asking him, and I've given him 5 opportunities. Mr. Brooks, do you have any requests as it relates to the jury instructions? I'll unmute you for that answer.
I can't hear everything you're saying.
Mr. Brooks, I know the audio is turned up. I believe you can hear me. You've chosen not to put the
Wow.
headphones on. That's your choice.
It's amazing.
My final question to you, do you have any requests as it relates to the jury instructions?
I just told you, am I muted? Am I muted?
No.
I just told you, I don't know how many times, I can't hear everything you said.
Then you should put the
What about
headphones
that,
on.
Don't you understand? What about that, don't you understand?
What don't you understand? What about that don't you understand?
The BBC headphones.
This is how he
Have
speaks
you asked
to
for
women.
headphones to be provided, sir?
I should have to ask him. I asked for my boxes to be moved.
And that's for my back.
I believe they took them away previously because you were so agitated, they were perhaps afraid you might break
Yeah,
them.
I'm still agitated. I ain't gonna stop being agitated. That ain't gonna stop.
This is what he's like.
You sit up here and do everything you doing and think God don't see what you're doing. You
God,
ought to be ashamed of
if he
yourself.
pointed those, hold on.
Mr. Brooks, do you have any requests?
If he pointed those comments to himself and really brought that into himself and thought about it, somebody's watching what I'm doing. Somebody's watching what somebody is. If you believe in God, it's God. If you don't believe in God, it's something else. Somebody can see. Thousands of people saw what you were doing on the 21st. Idiot.
As it relates to the jury
God
instructions?
bless.
I can hear what you're saying. I can hear what
Look
you're
at
saying.
him.
You just told me you didn't. So which one is
Yeah, I
it?
got the headphones on. You can't see that?
What are your requests as it relates? What are your requests as it relates to the jury instructions, sir?
Man, don't try to come with this whole little image, sir. Now it's all this sir and all this.
Ugh.
I'm gonna get where I'm going. Try to put on this little act like you so worried about what's going on with me. You don't give a damn. Never did.
Mr. Brooks, you're being disrespectful again.
You've been being disrespectful. You've been being disrespectful.
You've been being.
I need to know what your position is regarding the jury instructions. And I need to know it now.
What you mean? Who you talking to?
Who you talking to?
I'm talking to you. I need to know whether you have any requests as it relates to the jury instructions, sir.
Yeah, first of all, why am I charged with 2 bail jumpings when I was already charged in Milwaukee for the same bail jumping? That's double jeopardy.
That's not double jeopardy. Your objection is noted. It's overruled.
It is double jeopardy. How you gonna charge me with
I
the
don't even
same
understand
charge
it. Doesn't
I'm
sound
already
right to me.
You can't do that. The Fifth Amendment says that you can't place somebody in jeopardy of life and limb
You can't convict him twice.
twice.
You can charge
I'm
him.
already charged with the same count in Milwaukee. This for the same case. It's the same bail jumping charge. So how am I charged with that here?
Sir, I'm not going to provide a legal explanation other than to say I've reviewed that. Your objection is noted, but the jury will be instructed regarding the bail jumping.
It can't be because that's double jeopardy. Under the law, if two charges are identical in nature, you cannot place me in jeopardy of life and limb twice. You can't do that.
What's your next?
The same case number.
What's your next request, sir? I'm noting your objection.
I'm trying to talk. Can I get it out? You always want me to not interrupt you, but you always find a way to talk over me.
I understand your position. I'm saying it's overruled.
You always want respect, but don't want to give it. I'm charged with the same bail jumping charge here that I've already been charged with. That is double jeopardy. You can't charge me for the same exact bail jumping that I'm already charged with, that I was charged with before this even came about.
Sir, the bail jumping charges in Waukesha County are based upon your violating your bail while in Waukesha County by driving through the Christmas parade and allegedly killing 6 people and injuring 61 others.
Okay.
That's the distinction.
Again, there is no distinction. It's the same charge.
It's the same offense. It doesn't mean it's the same factual basis, sir.
He is not
It
charged
is.
with bail jumping with the data violation of November 21 in Milwaukee County anywhere. Further, the double jeopardy prohibition would prevent him from being convicted twice, not charged twice.
They can
All right,
charge
so
you with
we've
anything
addressed
they
that,
want.
sir. What other requests do you have as it relates to?
Even with my limited understanding, you can sue anybody you want at any time for any ridiculous reason. Remember the lady who sued the guy for the bad date for $10,000? I mean, that was ridiculous, and that man got drugged through it. So you can sue, and they can charge you, and then you have to answer to the charges. They might get thrown out for double jeopardy, but they can charge you. But I don't even think that's the case here. Way above my head. Okay, moving on.
To the jury instructions.
No, I want to know why I'm even charged twice with the same thing. You can't charge me in pursuant to a case in Milwaukee that I'm already charged with bail jumping for. I'm already charged with bail jumping for that already. So you can't essentially say, oh, well, because you were already on bail, we're going to charge you.
It's a different data violation, sir. The conduct for the bail jumping is related to the allegation that you committed a new crime in Waukesha County while out on bond from the Milwaukee County case.
Yeah, but I'm referring to the first bail jumping count. The first. I'm not referring to both of them. I'm referring to one of them.
My understanding, sir, is there's different dates of violations as it relates to that. So I've noted your objection now repeatedly. I understand it. Your request to, I guess, dismiss the bail jumping counts are denied.
I didn't say nothing about count. I said one.
Whether it's one count or both, it's denied.
Am I not being understood? You can't charge me with the same charge twice. You can't.
It's two separate cases, sir. There's two.
Isn't that 971.23? Isn't that the statute? That refers to the double.
All right, sir, I'm not going to have an argument. This isn't fruitful. I understand what you're saying. You're saying there shouldn't be 2 counts of bail jumping. You believe it's double jeopardy. I disagree with that. They're separate.
I'm already charged with it, though.
This is a circular argument, sir. It doesn't change the fact that, from my perspective, the 2 bail jumping counts are going to proceed forward. There's been sufficient evidence presented to warrant the jury being instructed.
They can't.
What other requests do you have,
You're not
sir?
gonna talk over me. Don't talk over me. Just like you don't want me to talk over you. Just like you don't want me to talk over you. Just like you don't want
Mr.
me
Brooks,
to
what other requests do you have?
And I just asked you not to talk over me. You've been making your record the whole time you've been over there. You had me muted. I didn't see no requests over there. I didn't write nothing to go over there. I let you do what you was doing.
You didn't have a
No
choice.
matter how egregious and biased it is, I let you do what you was doing.
Oh my God, you didn't even have a choice.
Because we both know that what you're doing is not right.
Mr. Brooks, I'm going to refocus your attention to the jury instructions. All of your objections are noted. I understand that.
Refocus my attention.
If you can't answer my question, I'm going to move on.
You can't. I haven't given you consent. Just like
All right, I'm going to mute him once again. He refuses to answer simple questions regarding if he has any requests. He just made an argument regarding the bail jumping, so clearly he has an understanding about the law as it relates to that. It may be a misunderstanding about the law and double jeopardy, but he made an argument. I've denied it. I'd like to know if he has any other requests. If he can stay on topic, I'll I will unmute him again, and he can tell me the list, just like the state went through a list. I need to get through their list. I'm asking you to list out all your requests, and then I will take each one up in turn. So here is your opportunity to give me your other requests, not debate with me about prior rulings. Go ahead, Mr. Brooks.
Don't sit up here and try to play no game talking about you giving somebody an opportunity that you haven't gave me an opportunity to properly defend myself and put evidence, put stuff into evidence, which I've asked you repeatedly to do before we even got to this class. You told me we wasn't in the evidentiary phase.
Mr. Brooks, do you have any other requests as it relates to the jury instructions? This is probably the 10th or so time I've asked you this question.
No, it's not. No, it's not. So please stop being incorrect, Your Honor. Please stop.
Do you have any additional requests as it relates to the jury instructions?
Yes.
Oh.
That first count 74 bill jumping needs to be dismissed. Can't charge me with.
Oh, she heard you. We
All right,
all
I made a note
heard
of that.
you.
What's the next issue?
Either one company gonna charge me with it or y'all, but it can't be both. It's the same. It's pursuant to the same exact thing that I was on bill for. The same exact thing. The same exact.
You know what?
So why are we
Fine.
getting the jury
Drop it.
instructions cases from another county?
I've made a
Drop
note of
it.
that. What other requests do you have?
Oh my goodness. You are losing it, Daryl.
I'm not even able to adequately defend myself, present evidence, do anything, because everything I say is going to be found a reason for it not to be valid. What are we doing here, Your Honor?
What are we doing here,
Mr.
Your
Brooks?
Honor? What are we doing?
Why should I be here when
I've made a note of your request as to count 74. Do you have any other requests as it relates to the jury instructions?
Why are we even having jury instructions? Why do I have
Why?
Because everything you've been doing without my consent anyway.
Without my
So you're
consent.
gonna find a way to do this without my consent.
Without my
So why do I
consent.
need to be here for?
Your objection for lack of consent is noted for the record.
Okay, yeah.
Any other requests,
You
sir?
talk a good game. You talk a good game to save yourself enough space. But everything got put up and has no merit in your court. None.
None.
Right, I've asked him many times, advised him, and I'll advise him once again. If he fails to answer the question, I'm moving
He doesn't
on.
even
Do you have any other
understand your
requests as it
question.
relates to the jury instructions, sir?
You can't move on.
You can't move on. You can't.
He did not answer. So I'm muting him again. The only request that he has made as it relates to the jury instructions, as he pounded his fist once again, raised his voice. I understand, I really do, that he's upset with my decision to cut off his ability to present a defense, but that decision was made based on his conduct and his conduct alone, as I've outlined already on the record.
Ad nauseum.
So the only request that he made was as it relates to the bail jumping counts. I'm denying those requests, whether it be to dismiss one count or to dismiss both on double jeopardy, or to just not instruct the jury. However way I interpret it, I'm denying that. All right, let me go through the state's.
Your Honor, can I add one more?
Sure.
Oh my goodness.
154 summary of evidence. I believe we had a map, actually two maps that summarize the, we had three maps. I think the one was summarized his route, the path that he took. The other one summarized the victims who were struck in the specific locations. And the other one summarized the positions of the law enforcement officers at the various intersections and throughout the parade routes.
I'll make a note of that. I don't believe I saw the jury view instruction either. I mean, that was given to them at the time. I don't know that it needs to be reread, but I think we need to consider that as well. And that was my version of 152. All right, so let me go through
He
the
does it twice.
list
I didn't know
from the
that.
state.
Look at him.
Turning to page 61. So I've considered the request by the state. I am going to rely on what information they put in the charging document. I'm going to deny the request to include the specific case numbers. There's evidence, of course, that was received regarding the 2 separate cases out of Milwaukee County that form the basis for both of the bail jumping counts. It will be up to the jury to review the evidence and make a determination as to the verdict forms, though, that were referenced previously, at least the description of them in the jury instructions. That obviously the third count of bail jumping is incorrect. That needs to be battery, and that change will be made. I'm also having Madam Clerk include all of the numbers for the jury instructions when they go back, so it's very clear. Some of them did not have them on, just frankly from prior cases that she and I have worked on, but in this case I want to be very clear with all of the numbers. So I think I've addressed the first 2 bullet points. As far as the motive instruction as a standalone, I believe that is appropriate, and I'll instruct Madam Clerk to include that. As far as where it goes, I'm going to just, any instructions that we add should just be in the numerical order, unless there's a other request that's made. Then the state also made a request as it relates to jury instruction 70, which is found on page 65.
He did it twice.
So as it relates to this, the state is asking that I simply
He did it twice. Oh my God.
instruct the jury
No
based on
way.
the pattern instruction and not include that second paragraph. I had previously advised the jury with another paragraph that I was contemplating including, even if I took out that big paragraph that just said, "At times Mr. Brooks has appeared from another courtroom. This must not influence your verdict in any manner." What's the state's position on including that?
You can
and
say
taking
that all you
out
want.
the paragraph you request to be taken out?
That's fine.
Mr. Brooks, do you have any position on that? Which is, so jury instruction 70 has to do with the defendant proceeding pro se. The pattern instruction would be basically the first paragraph. I need the bailiffs to move the boxes away from his face. I need to be able to see him. He can keep them on the table, but they need to be moved off to the side. And if he does it one more time, then I will instruct the bailiffs to take the boxes away. Those are trial prep materials. If there's something in those materials related to jury instructions, he should take those out now. Otherwise, they need to be moved away from the microphones and away from blocking his face.
I'm not putting them there, I'm not putting them there, you can't see them, I'm putting them there for a reason, and nothing to do with her, and they can see.
Mr. Brooks, do you have any position on the verbiage of jury instruction
Don't ask me-
70
don't
on
ask me
page
no question.
65?
Don't ask me no question. Are you my accuser? Are you my accuser, Your Honor?
All right, he's choosing not to answer, so I'll mute him again. It's unfortunate that he's deciding not to participate in this. I agree with the state. I don't need to highlight with that second paragraph. I will take that out, but I will include in the paragraph that reads, "At times, comma, Mr. Brooks has appeared from another courtroom, period. This must not influence your verdict in any manner." Inclusion of the instructions that were put on the last couple of pages include 325 impeachment of witness. Its prior conviction, the part about juvenile adjudication, should be struck from the heading. And it should read, evidence has been received that one or more witness in this trial has been convicted of a crime. There were 2 witnesses that was applicable to. The remainder will be as is. And that was 1 witness for the state, 1 witness for the defense. I just will add that if Mr. Brooks has any position about these requests, he should He is currently muted. He can raise his hand and I'll unmute. Otherwise, he can pass a note to the bailiff or simply tell the bailiff, who can then tell me, and I can unmute him. But unless he tells me that, I'm going to assume he's made a decision not to provide further comment based upon the last statement he made to me. Then 141, I believe that's appropriate given the evidence that has been received. That's on identification of defendant is in issue. That I will instruct the jury accordingly unless there's a request from Mr. Brooks to take that out. Is there a request from you, sir, to take 141 out? I'll unmute for that purpose. It's found on page 106 because it's at the end of the instructions. This is the instruction on identification of the defendant and where it's at issue in a case. I believe it's appropriate given the testimony in this case. Do you have any position on that, sir? You are unmuted, so you can simply answer yes or no. No response. Then 172, circumstantial evidence, flight, concealment, I believe is appropriate given the evidence that has been received during this case. Yes, sir?
Am I unmuted?
You have been.
Am I unmuted?
You are.
So how long before you mute? As soon as I say something?
Depends on what you say, how you say it, and if it's responsive to what we're doing.
Why do I have to be responsive to what you guys are doing? Nothing I say even matters at this point. So what's the point of me being responsive? You can't make decisions for me.
Mr. Brooks, I'm going to mute you unless you can
No, she's just
participate
interpreting
in
the
what we're doing,
decisions
which is
you're
discussing
making.
the jury instructions.
I'm not gonna tell the jury the truth. That's what I'm gonna do.
The
I'm
truth.
gonna tell them what hasn't been told to me.
Oh my gosh.
I haven't been able to.
Mr. Brooks, I'm going to mute you because we're trying to discuss the jury instructions, not what you're going to say during your closing argument. I will get to that later. In terms of instruction 172, I'll instruct Madam Clerk to take out of the heading the word escape. Should just say flight concealment. And then I've reviewed 154. I believe that's appropriate. I'm going to pull it up just as a draft. I'm not sure if there's anything that needs to be.
Skip ahead a little. We're only going to go.
My
a couple more
inclination, but I
minutes.
wanted to get the party's position on that. I'll once again unmute Mr. Brooks and just ask him if he has any position regarding any of these last issues that we've discussed with, as it relates to the jury instructions. Anything from you, sir, on the jury instructions? He's not responding to the question.
Dope. What a dope.
I believe that covers all of the issues that were raised by the parties then. You are. I'll give you one final opportunity to tell me if you have any requests as it relates to the jury instructions, sir.
What you mean you give me one final thing? I didn't consent to nothing that y'all been talking about. And I say y'all because I haven't been participating in none of that.
I understand, sir. Your objections noted. Your lack of consent is noted.
Okay, I don't see what's going on in there. So how's decisions being made without me being able to consent to it?
Sir, you forfeited
don't
your right to be
consent
present
to
in this
anything.
courtroom by your conduct, and you have not requested to come back.
Actually, you took a break. So let's make sure the record is correct. You took a 10-minute break.
I did.
At which time I was brought back into this courtroom.
I was advised you wanted to stay, sir.
Okay, and you've been forcing me to come over here from the get-go. Why couldn't you force me to come back over here where I'm supposed to be at?
Sir, my understanding is you requested to stay in the other courtroom. I thought I put that on the record at the beginning. If I did not, I'll make that part of the record now. I was advised by the bailiffs that you were requesting to stay in that courtroom. I certainly advised you prior to that if there was a time you wanted to come back in, all you needed to do was ask. You've done that previously.
Yeah, but
And even during this time, though, you've been incredibly disruptive.
I can't say this.
During,
Have.
I mean, at one point you were muted for an extended period of time and you were yelling so loud, sir. We could hear you in this courtroom. I couldn't decipher what you were saying, and I was also made aware that another branch could hear you. So you continued your disruptive behavior.
That's fine, because at the end of the day, I should be heard. I have the First Amendment right to be heard.
No, you don't.
So if I'm going to be constantly
Not like
muted,
that.
the only way for me to be heard is for me to raise my voice.
Mr. Brooks, one final time, do you have any requests as it relates to the jury instructions? Otherwise, I'm going to approve them. I'm going to take a break, and then we'll come back in the afternoon to go over verdict forms.
I didn't answer yes or no, so how do you consent to anything without me answering the question?
Are you going to answer the question, sir?
But you can't force me to do it. You can't just say, I'm going to do this. Because
Sir, but you also can't stall the proceedings by failing to answer.
I didn't try to start the proceedings. You the one that held me in contempt.
I never held you in contempt. All right, I'm going to mute him once again because he refuses to answer a very simple question about whether he has any requests as it relates to the jury instructions. I will work on making all the changes with Madam Clerk, finalizing the order, print them off again. She has been working on the verdict forms, which are of course separate, which need to be approved by this court. And so those will be printed off. A set will be provided to the state. A set will be provided to Mr. Brooks. We'll take I'll do a 90-minute lunch break, so it's 11:27. So we'll come back at 1 o'clock to finalize the verdicts and the jury instructions.
And Your Honor, with regard to sequestration of the jurors and the alternates and those issues, did you want to address those this afternoon?
Yes,
Okay,
we can do that.
thank you.
I can put on the record that I had the civilian jury bailiffs provide the parties. We have a letter regarding sequestration. There's an emergency contact form, so all of the jurors were made aware of that. They know that. Of course, once the case is, all of the instructions are read and the parties make their arguments, and then there's some final instructions at the end, and the case goes to the jury. Obviously, only 12 of the 15 will be deliberating, but we can make a more full record of that this afternoon.
Thank you.
All right, we are in recess until 1 o'clock. I'm just instructing the parties to stay until the handout of the verdicts, and then you can leave for lunch. Thank you.
Woo! That was one excruciating. I want to thank everybody who subscribes. I think you guys are great. I hope you are at least clearing the decks of this particular trauma, because I feel that we've all been traumatized by it now, and I am starting to feel a little bit more centered about this. When I first heard about it was right when it happened, because I have a friend who lives in Wisconsin, and we both were very involved in, especially my younger years, but you know, he's taught marching band, I think, for years and years too. So it hit him very hard, and I couldn't even address it because of working in the fire department and having kind of a full bucket of trash to carry around emotionally and mentally for that. But this man is just a walking, talking trauma to everyone around him. Wow. But I do want to thank you. All your comments are great. I am so woefully behind on those. It is incredible. There's like, you know, back a couple, but I do have a few days off this week, so hopefully I'll be able to do a bunch of videos and go over a whole bunch of the comments and everything, and I do appreciate it. I didn't expect any of this to go at, even to this level. So thank you so much. This is Patty Jo. Subscribe, comment, share, whatever it is that you do that makes you happy. And thank you so much. Okay, stopping.